Yes, Mr. Coppell.
Thank you, my lord. Just a handful of points to rise out of the submissions this morning. The first is my lady asked for the reference to the evidence on there being not enough time.
See if I've beaten you to it. Paragraph 61.
61.
And the point, you know, there's a follow-on point from there, don't you? Because, forgive me, because the judge, I think with respect to her, may have misinterpreted that evidence. Because the evidence of Miss Hunt was to the effect that there was not enough time to brief a brand new agency. And therefore her following sentence, and we're not here to unpick the findings of fact, I understand that, but the comparison that she then makes about but Miss Stratton could brief Britain Thinks is not a good point, because Britain Thinks was not a brand new agency.
Yes, that's not with respect to the point that the judge is making, though, in 162. It is that there was a guide produced for Britain Thinks, which was already doing similar work.
Yes.
Which was used to brief Public First, which was at the time of that briefing a new agency.
But am I right about paragraph 61 at page 154? If that was the reference you were going to give me.
Well,
which bundle are we in? Forgive me.
Supplementary 154.
My fault, I'm looking at the wrong one.
So paragraph 61, given the speed at which events were moving, we did not have time to brief a brand new agency. Now, if there's another reference in Miss Hunt's evidence that we haven't found, that will be helpful. But if this is the evidence, it was time to brief a brand new agency. May not matter.
Yes. So
page 154, para 61, I think is the evidence referred to at 162 of the judgment.
Yes, but the point made by the judge is that they briefed Public First on a sixpence using a guide which they already had from Britain Thinks. They could have briefed somebody else.
But her point, she's saying, there was time because that Public First could be briefed. Well, Miss Hunt wasn't saying there wasn't time to brief Public First. She was saying there wasn't time to brief a brand new agency.
Yes, which the judge said, well, let's look at how long it took you to get Public First up to speed. Answer, no time at all, because you had the existing guide that you used for Britain Thinks. You can't say that they had to be appointed because there was simply no time to brief somebody else.
Right, okay.
But Lady, all of this is ex post facto. Ms Hunt was not there at the time, as she goes on to say in the in her. I'm sorry, she says it above in the same paragraph. 61. She wasn't there at the time. She wasn't the decision maker. Nobody asked her to think about, do you have time to brief somebody else, because nobody else was considered. Second point, paragraph 141 of the judgment, my lady also asked about whether the judge's statement of the law was correct in respect of the decision maker detailing what was in his or her mind at the time that she took the impugned decision. Well, we certainly accept that one can't take that too far, in the sense that we know from cases like Condren that the decision-making process, the process of consideration, the discussion which preceded the decision, is a factor which the fair-minded and informed observer may take into account. Fact, but that's not. In that case, you had objective evidence. You had minutes of the committee meeting, so it wasn't simply the decision maker saying, "Well, I've got nothing in writing, but I can tell you that I thought about A, B, and C." You actually had objective evidence, and the judge may objective and contemporaneous evidence, and there is force, we say, in what the judge says, that in the sense that the observer will be much less reassured by an account from the decision maker as to what he or she considered, which isn't supported by any objective evidence. But the key point about 141, lady, is that this issue about what was in the mind of the decision maker at the time, it doesn't arise on the facts of this case, because the judge found in terms, in paragraphs we looked at earlier, that, so it's 158 and 160, that the defendant's justification was not in the mind of the decision maker at the time that the decision was taken. So,
where did that actually come from? Did they say so?
Well,
where's the evidence to support that finding?
Well, it comes from Mr Cummings and Mr Aiken, who
right.
Mr Cummings was the driving decision maker.
Yeah, that's what I want to know.
And Mr Aiken implemented, signed off what he decided. And the judges...
I'm not doubting you in one sense, Mr Coppell, but I thought I had read evidence from Mr Cummings saying that part of his thought process, however you described it, was that public first, I'm looking at 157 Roman numeral 2, were trusted, known to be capable of undertaking the required services speedily and effectively, and of debriefing under pressure. How can that not have been in his mind at the time? I mean, well, is the evidence from him not that was part of his thinking?
The evidence from him is, as the judge...
As it stands, but if we look at it, that's why I think my Lord may have asked. My recollection of Mr Cummings' witness statement was that...
Well, he certainly expresses a positive opinion about public first, but the judge's point is that the comparison and the question of whether anybody else was considered, whether anybody else was available, that was simply not in the mind of the decision makers. Well, paragraph 8 of Mr Cummings.
Yes, that's exactly right. Sir James took us to that, and he says at paragraph 18, those were my reasons. So part of his reasons were that they were very good, extra effort, and so on and so forth. Anyway,
and what the judge says about that paragraph is in 159 as well, that those factors and his view that public first were competent, honest, and reliable was a necessary but not sufficient basis, so far as the provided an informed observer would look at things.
Well, that's why I asked you the question earlier about whether that statement was in fact conditioned by the informed observer point, but
well,
seems to be a rather basic, rather broader statement, but maybe not.
Well, there certainly are findings of fact in 158 and 160 which aren't challenged and couldn't be challenged, as we submit on the appeal. But all of this is in the context of whether the concern which the fair-minded observer would have felt about the personal friendships was allayed by the decision-making process. The third point, 147 of the judgment, I just wanted to make the point that this paragraph indicates that the judge was influenced to some extent by Regulation 24, because the language that she uses in the first sentence, personal connections being a relevant circumstance that might be perceived to compromise impartiality and independence in the context of a public procurement, those words are drawn from Regulation 24. One sees them at the top of the next page. Personal interest is substituted for personal connections between the individuals involved. But she's undoubtedly thinking of the sort of considerations on apparent bias, which Regulation 24 required her to be considered. Fourthly and finally, paragraph 93 of Lewis, just a reference for the court as you'll be looking at Lewis, refers to the approach to be taken to apparent bias across the whole spectrum of decision making. And ultimately there may not be that much between the parties that apparent bias is an applicable principle in this context of public decision making as in others, but the context will have some influence on the way it is applied. See paragraph 93, Lord Justice Ricks. Sir James's submission that I was coming to in relation to apparent bias and Regulation 32 is that the judge's findings on apparent bias cut across Regulation 32 because he says the fair-minded and informed observer would understand that once Regulation 32 is applicable, once the urgency has been shown, the defendant is not required to conduct any further process. And so the fair-minded and informed individual wouldn't expect the defendant to do anything else by way of documenting or considering anybody else for the contract. And we respond to that submission in our skeleton argument, and it's in particular from paragraph 63 onwards. And there are 2 points that I wanted to highlight at this stage. One is the point in paragraph 63 that it is not right, and I paraphrase, that once the urgency is shown, all bets are off, that there's no further obligation. That is not right. And we make the point about halfway down 63 that the effect of there being grounds for invoking Reg 32, negotiated procedure without prior publication, is only to disapply the requirement to call for competition to advertise and not to disapply general principles of transparency and equal treatment from which the duty to consider alternative suppliers would flow. That follows from the scheme of the regulations. It also is a point made by the European Commission in its guidance, which the judge held to be a correct reflection of Regulation 32. And in the judgment, at paragraph 84, page 52, there is a 2.3 quote from the Commission's guidance.
I'm just catching up with you, so could I have the paragraph number again?
Paragraph 84.
Thank you.
Starts on 51 and goes into 52.
Yep.
2.3. In cases of extreme urgency, the Commission advises that the negotiated procedure without prior publication can be used. This procedure remains exceptional. All conditions have to be met cumulatively are to be interpreted restrictively. And then this, a negotiated procedure without publication allows contracting authorities to negotiate directly with potential contractors. A direct award to a pre-selected economic operator remains the exception.
Yes.
Applicable if only one undertaking is able to deliver within the technical and time constraints imposed by the extreme urgency. The same point is made by the Commission in its introduction and which is not transposed into the judgment, but 614 of the authorities bundle. But the point is this, that once the urgency is shown, you don't have to advertise, you don't have to follow a prescribed procedure in the regulations, but you do, in principle, have to consider more than one economic operator. You can't simply pre-select and say, I know that Public First are good chaps, I'm going to give the contract to them without considering anybody else. That would contravene Regulation 18, which continues to apply, notwithstanding Regulation 32. Now, that's not a claim that we ran in this case. We didn't have a claim of breach of Regulation 18, but it is not the case, and I say this in response to Sir James, it is not the case that once Regulation 32 applies, nothing further has to be done. There will be circumstances where only one supplier is able to do the job in the time. That's what the defendant said this case was. But the judge rejected that. So that's the first point, and it must be right. It can't be the case that just because there is urgency, the authority is then free to appoint to whomever it wishes, friends, relations, UK nationals, without any sort of objective criteria or consideration being brought to bear.
Won't that be entirely fact sensitive?
Sorry, my lord.
Won't that be entirely fact sensitive and not capable of rules in advance?
Yeah, so there is no.
If it was a nuclear bomb, then things might be different to a pandemic or some other form of urgency.
Yes, my lord, that is absolutely right. What has to be done will be fact sensitive. But I make the point in this context simply in response to my learned friend saying, well, why would the well-informed observer expect us to do anything else when Regulation 32 allows us in all cases to award the contract to whomever we wish once urgency is shown? So that's the point. And if one does look at the facts of this case, the judge considered whether there was so much urgency that only public first could be considered, and she rejected that on the facts. The second point that I wanted to highlight in response to my learned friend is in our skeleton at paragraph 65. So, and perhaps it's another point that one has to look at the factual context. What the judge is deciding is that given the starting point of a concern about the friendships between Mr Cummings and public first, there was a necessity to take further steps by way of records, objective consideration, as Mr Boardman might have it, testing the market to some extent. So the judge is not prescribing what has to be done in any other case. Her decision is simply that given that starting point, what actually happened did not allay the concerns of the fair-minded observer. Indeed, it exacerbated those concerns. So that brings me to the cross-appeal. A little later than hoped. We have 3 points on our cross-appeal, and they all go to whether the express requirements of Regulation 32(2)(c) were satisfied. As I mentioned before, no dispute on the judge's account of the principles, 86 to 93 of the judgment. The first point that we make is that, and if the court can take up Regulation 32, it's in the judgment at page 51. That's the most convenient place to put it, place to see it. and you see 32 sub 2, the negotiated procedure may be used, and C, insofar as strictly necessary, where for reasons of extreme urgency, ordinary time limits cannot be complied with. And our point, our first point on the cross appeal is that it was not strictly necessary for the defendant to invoke a negotiated procedure and to make this direct award to public first, because there were contractual arrangements already in place with other agencies to provide services of the type that were needed. Those arrangements had been entered into following procurements conducted under the regulations, and the agencies in question, Jigsaw for example, had competed for and had won the right to provide services to the defendant and other government departments in those procurements. Now, the judge held at 109 and 110 that the existence of
Excuse me, but I've got something stuck in my throat, so it's all right, I've got some water. Just give me a moment. Okay, let's try again. I think it was a bit of apple. Sorry to interrupt you.
No, the judge decided at 109 and 110 that the existence of alternative suppliers who already had contracts, which would have avoided the need for any new contract at all, she said that was irrelevant to the Reg 32 criteria because, take 109, because the defendant was at liberty to decide that it wished to obtain services from an agency with whom it did not have an existing contract. Same point is made at the end of paragraph 110. And we say that cannot be right on the words of Regulation 32 because it cannot be strictly necessary to use this exceptional procedure if you have ready access to precisely the same services on a lawfully procured contract. That would be inconsistent with strictly necessary, with the exceptionality of the procedure, with it being strictly construed, with it being a heavy burden on the defendant authority.
But is that tantamount to forcing the government to contract with a particular party just because, as it happens, there's an existing contract?
Well, maybe it had already contracted with Jigsaw. Jigsaw had an on-call contract for precisely this kind of work, and indeed it came into the picture later in March.
This kind of work, but not this work?
Well, yes, this work, focus group, provision of focus groups.
Yeah, but not for COVID.
Well, not for COVID, but provision.
The judge deals with this, doesn't it? I mean, we need to be realistic. 111, the judge says, in relation to Jigsaw, contract would expire in March 2020, and therefore there would have had to have been a fresh procurement.
Yes. So
it's back to the facts.
Well, so the point on. I mean, can I come to the facts in a moment? I've got one more point to make about the principles. It would have, we say, serious implications for policies of transparency, equality of treatment, and fair competition, which are promoted by the regulations, if an authority was permitted to decide with no constraint whatsoever not to use contracts which it had lawfully procured and instead make a direct award without competition to somebody else, to a preferred supplier. And what perhaps it's simpler to look at the point in relation to a simpler product. You take paper clips or widgets, and the government has a contract lawfully procured, whereby a company has the contractual right to supply widgets to government departments. There is then an urgent need for widgets as a result of the pandemic. We say it's not strictly necessary to procure another contract for widgets because there already is one. And the same argument, cleaning services, for example, and the same argument with these services. And one looks at the way the services were defined in the contract. Now, on the facts, the point about 111, well, one needs to go to 163 for the fact that Jigsaw was engaged, halfway down 163, Jigsaw was engaged to carry out focus group work on COVID-19 opinion research, so that was covered by its contract, indicating that it did have relevant experience. Now that's what happened, and we've set out the factual points in a little more detail in paragraph 71 of our skeleton argument. The position was that Jigsaw had a contract until the end of March 2020, so throughout the immediately urgent period when Public First was called in, and we quoted the evidence on that in paragraph 71 of the skeleton. And subsequently, that contract was lawfully extended under Regulation 72 of the regulations. And we've cited the evidence on that in footnote 13. And so you have a provision in the authorities bundle. There are circumstances where it is lawful to extend an existing contract, for example, to cover a slightly longer period. Certain reasons have to be shown. Now, so it may be that the judge, by a new procurement procedure, was referring to Regulation 72. I don't know, but it's simply not. It's not correct on what actually happened to say that a new procurement procedure was needed to engage Jigsaw. Jigsaw was engaged, had a contract at the end of March. That contract was extended. And those are facts you find elsewhere in the judgment. And the point in relation to Britain thinks is that the judge's factual finding on Britain thinks is in on this issue is in paragraph 23, where she identifies the government's additional need as for focus groups. Britain thinks was an existing provider of focus groups, which simply wasn't asked whether it was able to provide any more. We also rely on YouGov, 163 of the judgment, where the judge rejects Ms. Hunt's after the event opinion that YouGov wouldn't have been able to do this work. Again, existing contract with YouGov, it's one of the largest agencies, and the judge says, well, it simply wasn't approached. And in a context where the burden is on the defendant, and it's a strict burden, it's not good enough to make the sort of assertions that Ms. Hunt made without YouGov ever having been asked. So, alternative suppliers, first point. Second point is the duration of the contract, which was a 6-month contract. And you have it at 192 of the core bundle. It's 186 of the core bundle. Dated 5th of June, paragraph 4, but the effective date of the contract is the 3rd of March, and paragraph 5 is the parties agreeing that they are recording what they thought the position was on the 3rd of March. Paragraph 6 over the page, the expiry date is the 2nd of September. Some suggestion in the defendant's skeleton that it was a maximum of 6 months. That's not correct. It was a 6-month contract. And while we're here, you have on page 189 the statement of what services were to be purchased under the contract, recruitment and delivery of focus groups and or mini groups to degree specification. And my next point will be that the scope of the contract was not confined to the urgently needed services, went significantly beyond that. So, a 6-month contract, turning to our skeleton arguments at paragraph 73, judge accepts scope and duration of any contract procured must be limited to what is strictly necessary. We quote the Commission guidance to the effect that what is strictly necessary is what is required to cover the gap until a more stable solution can be found. And you see that on page 52 of the judgment, just above paragraph 85. Negotiating procedures cover the gap. They meet immediate needs. They cover the gap until more stable solutions can be found. The defendant's pleaded case, see paragraph 76 of our skeleton, the defendant's pleaded case, in its detailed grounds, was that a competitive procurement process could not have put a contract in place before the end of March 2020. So the defendant's timescale was 4 weeks approximately from Public First's appointment, 4 weeks from the 3rd of March, to put a contract in place under using a speedy but competitive procurement. No suggestion that a competitive procurement would have taken as long as 6 months to get organised. And in 77, we quote the defendant's expert internal advisors, I say internal advisors in the Crown Commercial Service, advising the defendant's officials that the contract shouldn't last more than 12 weeks. If we continue to have a need after 12 weeks, I hold the view we should be tendering the work. It's not a difficult thing to re-tender. There are other suppliers who could and should be provided with the opportunity. And that's his job, this Mr. Sutel's job, to advise government departments on their procurement practices. He says no more than 12 weeks. And what we end up with is a contract for 6 months with no consideration of what was strictly necessary in the circumstances. Simply not called to anyone's mind what was the minimum, at the time, what was the minimum possible term of the contract. And if it had been, you wouldn't have had a contract that ran through June, July, August, September of 2020, when we were all eating out to help out, and the immediate urgency of the pandemic had subsided.
There certainly was consideration to the length of the contract, because of course it was reduced, wasn't it?
Well, it came down from 9 to 6.
So
yes.
you can't say there was no active thought given to the appropriate length.
There was no active thought given to what was strictly necessary.
And the basis for that, where's the finding to that effect?
Well, what the judge says is that our complaint that 6 months was too long was based on hindsight.
Yes. So where is the finding that nobody gave any thought to the minimum period? Because my reading again from the evidence was that active thought was given to duration, and the biggest concern was to avoid a gap. There had to be continuity, and nobody knew what the future held.
Yes. And really, on the point about nobody knew what the future held, I'm taking the judge's finding and I'm turning it around, and I'm saying the burden was on the defendant. There isn't a reasoned decision as to what was strictly necessary, what was the minimum to cover the gap. There were discussions, but nothing set against the legal requirements. As to the point that there was uncertainty as to how long the pandemic would last, well, that tells against the defendant entering into a long contract when it can't be sure whether the contract will still be needed in 3 months, 4 months, 5 months, 6 months. And certainly not to do so in June, when on any view the initial urgency had subsided.
So the judge dealt with the argument, as you say, 114 to 117. Just for my note, what's the point of principle in relation to duration?
So the point of principle is the judge says that this is all a matter of hindsight on the claimant's part, paragraph 116, first sentence, and then 117. There is a point of law, pure and simple, where she says that Regulation 32 does not limit the duration of any contract falling within its ambit to the shortest period of time required to conduct a competitive procurement exercise. Now that wasn't exactly what we submitted. What we submitted was that strictly necessary, and as the judge had previously found, the duration must be limited to what is strictly necessary. What we said was that is, see the Commission guidance, until such times as a properly procured contract can be put into place. Your position is it can only be for the duration of whatever period is necessary to carry out a full procurement exercise in any circumstances. And necessary may be where we can't do it. We don't have the capacity to do it. So it's not simply a case that necessarily of looking at the time limits in the regulations, but it is how long is necessary before you can put a properly procured contract in place. That's what the Commission says. And here there was some uncertainty, but the defendant responded to that by putting in a much longer contract than was strictly necessary. And finally then, on the scope of the services, the judge regarded our complaint, and just so you understand, our complaint is that a few weeks after the 3rd of June, the Public First stopped doing COVID-related work, and it moved on to different work which is not alleged to have been urgent. And
this was when, in June?
so this was on the 3rd of July.
3rd of July, forgive me, yes.
So the first evidence of it is supplementary 292 to 93. Public First is saying to Cabinet Office, we're moving to other research from next week. What was the other research? It was, and this is in the supplementary bundle as well, from 288 to 291, is research about public attitudes towards the Union with Scotland, public attitudes towards skills, training and lifelong learning, public attitudes towards the planning system. So not COVID related, not urgent at all. And the judge says, well, that's simply a matter of how the contract was performed, and there's no complaint can be made in relation to that, and that's 123. She says this judicial review does not extend to scrutiny of subsequent performance. But the problem, my Lord, is that the contract was not confined to urgent services, to the urgent COVID-related services, which was the justification for its being awarded in the first place.
So you say that's not performance, that's the scope of the contract.
The scope of the contract as awarded. Got the specification, the parties agree, that's what they thought on the 3rd of March, that's certainly what they thought in June. And just stepping back, what one in fact then has is a contract which was originally awarded for urgent services, according to the judge, which is expressed in such broad terms and covers such a long period that it can then be used for things which it should never have been used for at all. And the judge gives us the figures, and it was around about £100,000 worth of work. At the end of paragraph 61 of the judgment, around £100,000 worth of work was done, of this non-urgent work was done within the contract specification, but that specification went beyond what was strictly necessary. The work ended under the contract at the end of July, coincidental with the claimant's pre-action letter in these proceedings. So no work was actually done in August and September, but there was this £100,000 or so done in July.
Just as a matter of interest, because it's not a detail I've picked up, was it actually terminated in accordance with the provisions that allow for termination either side?
I understand that it expired in September.
So it was just dormant
It was
from
just
July, because as I've understood the annexes to the short document you showed us, there's the provisions that allow both parties, as one would expect, to bring it to an end, I think, on 14 days' notice.
Yes. As we understand it carried on, but no orders were placed, no work was done. Proportionality, finally, in a sentence, requires the court to step back and to ask whether how the defendant responded to its urgent need back at the beginning of March 2020 was proportionate in the circumstances. How it responded was to award a contract for 6 months for £840,000 for a scope of services which went considerably beyond what was said to be the urgent services back in March. And standing back and looking at the matter as a whole, we say that was a disproportionate response contrary to the EU law general principle which applies in these procurements. I'm sorry for overrunning.
You're not the first. And if you, I don't mean to stop you, Mr.
No,
Collins.
I'm sorry. Those are my.
And without, I hope, putting any pressure, we would imagine that Mr. Boucher could perhaps be a little bit less than an hour.
That's the aim. My lord, my lady, I'm only going to be dealing with grounds 1 and 2 of the appeal. I propose to make some general, first two items, to consider the scope of the appeal on these two grounds, which to some extent involves just reviewing the key facts which are already in the judgment and to really define the parameters of the available appeal. Then to make some general observations about Regulation 32(2)(c), which may be helpful simply because I don't believe this provision comes before this court that often, and it may be appropriate just in 10 minutes to look at a few general propositions, and then to address the 3 specific elements of the appeal. But I will be doing some of that at pace, so if I miss something out, I'll have to come back to that. The short question about the availability of Regulation 32 does not arise. This is not a case where there's any question as to the available circumstances. It is a given that the circumstances that prevailed at the relevant time justified the adoption of a procedure to award a contract without going through the PCR. The only question that arises is whether or not the Regulation 32 permitted the award of this contract in the terms that, given the matters that Mr. Coppell complains of. The appeal addresses therefore only a limited part of the concept of strict necessity under Regulation 32(2). It is a given that there were reasons of extreme urgency and so on and so forth. The pandemic was upon us. It was appropriate to buy focus groups immediately. And we'll come back to this, but it is found more than once by the judge in her judgment. It was appropriate to buy focus groups from more than one source. She had quite a bit of evidence from the defendant, and she adopted the notion that it was appropriate, if you're doing this, taking on this task, you would want to have more than one source of that service. And of course, as she notes in the judgment, the urgency of the situation did not allow the luxury of time for a competitive tender. And therefore, the decision was taken by Mr. Aiken, first on the 27th, 28th of February, to purchase the services immediately. And the quickest way to do that was to use the existing provision that was available. Honourable Justice Coulson's permission decision identifies a number of fixed points in the judgment around findings of fact. And I won't go over them all in detail because I apprehend the court's got them well in mind, but paragraphs 110 to 113, 116 and 123 do put a number of pegs in the ground which constrain the number of points which my friend Mr. Coppell wants to make. I've already made the point. The defendant wanted to have data from different sources to check its reliability, and the reasons for this, the judge said in paragraph 110, were not for the court to criticise, and there's numerous references in the evidence of Mr. Cummings and Mr. Aiken on that point. And there are specific findings, paragraph 112, that engine was not an alternative, BIT was not an available route, and that, if one needs to go through the evidence on each of those, they're given by Ms. Hunt in her evidence, tab 13, page 235, where she goes through, for example, the reasons why YouGov were different. And that is one of what comes out of that evidence, of course, is that these were all different agencies with different skills and expectations. With respect to Mr Coppell, the widget analogy simply doesn't work here. The whole point was different agencies were providing different, would be expected to provide qualitatively different sorts of product. They're not necessarily interchangeable. Further, this point's already been made, there were specific requirements of continuity. That comes from paragraph 116. I won't make it continue further. Also, paragraph 123 of the judgment, the scope of services defined in the contract corresponded with the scope of work identified as required. So, as defined in the contract, that was an appropriate specification of services needed urgently. And then from Mr. Coppell's point about the move on to other services is a complaint about a change which was made, and that is explicitly spelt out in the judgment as being a change rather than a reflection as to what was in the original scope of the contract. As originally let, was an appropriate scope of contract, scope of services.
What's the reference for the change? It being a
sorry.
change.
Can I come back to that?
Yes,
I know
I read 121 of the judgment in a rather different way. I thought it was saying it was very open-ended.
Oh, sorry, no, it's earlier on. Paragraph 60.
Thank you.
Well, in her chronicle of the facts, maybe I'm drawing an inference, but she makes the point it's an extension of the services in July.
So it's a variation.
It's a variation of some sort. And then just to put the flag there, that of course, that either would or wouldn't raise an issue under Regulation 72, which you have in the bundle. There's a separate provision in the regulations about modifying existing contracts, and a separate question about whether you should be permitted to modify an existing public contract. But that would be a Regulation 72 issue, which is not what this challenge is about. And one final preliminary point of this type, which is overarching across a number of Malone and Friends arguments. He does not have any pleaded basis for relying upon equal treatment or transparency as a springboard for any positive position in this case. There was an attempt to amend the challenge, shortly before the trial, and that is in the supplementary bundle at page 98. And the judge did not permit the claimant to amend its pleading to bring in an additional ground of challenge that the approach taken was contrary to equal treatment and transparency. And there's a very short reasoned order to that effect. So insofar as he's trying to construct a claim which says that in some way or other our performance within sort of accepting that Regulation 32 applies, but that we were still subject to Regulation 18, and that there can be some positive challenge made to us under Regulation 18 nonetheless, that's simply not available to him in this challenge. Regulation 30. So turning then just to a few general observations on Regulation 32 to C, and I won't cover the whole territory, just to try and find the points that are relevant. Because the judge has well summarised the context from paragraph 76 of her judgment, and she summarises its effect at paragraphs 87 and 92. The key point is that the effect of Regulation 32 to C is binary. What do I mean by that? If you are acting in pursuant to 32.2c, if you have decided that you are not going to make a call for competition and you're going to act pursuant to the freedoms provided by 32.2c, you do not have to make a call for competition. And that is, of course, the key trigger for much of the machinery of the public contracts regulations. Because if you don't, and that is made absolutely explicit by Regulation 26, which tells you, in Regulation 26.2, already been there, that if 32 applies, no, you don't have to make a call for competition. What is a call for competition? There's a rather circular definition of it. It's in Regulation 2, page 13 of the authorities bundle. A call for competition made in a manner required or permitted where relevant by one of the notices. It's the sort of thing which looks like an OJU notice of the type that many will have seen. It is the way by which you ask people to submit tenders. But if you don't make a call, if you're not required to make a call for competition, you're not going to have tenders. And that's the point. You will not have a tender under the regulations if you haven't made a call for competition. That's not to say there isn't a market, and that there aren't alternatives, but there won't be a tender, and you won't be in the processes of all the various regulations in the regulation set out in the statutory instrument. Now, there are obviously some surviving obligations about notification and so forth which are set out, which they apply in it, they continue to apply. But there is no call for competition. And the importance that flows from that is not only that you are not required to go out to competition, you're not required to think about how to run the competition. And this, to some extent, is treading on Sir James's ground here, but I'll do it very quickly. It would be absurd if the effect of Regulation 32 would be to take you out of the world where you have specified procedures, open procedure, restricted procedure, etc. You know what to do, you follow the rule book. And suddenly you're in an emergency, but you're required to do something, but there's no rule book about how it is you are to run the process. You're suddenly having to devise a new comparison process, whatever that is, without any rules by which to do it. The whole point of the Regulation 32, that's why I say it's binary. Once you are freed from the need to make that call for competition, you are left in a position where all that can apply are the few remaining transparency obligations specified in the regulations and perhaps some general public law principles. But that's what would remain. And that becomes important when you're starting to think about, well, for example, if Britain thinks an available alternative, is Jigsaw an available alternative? If you were doing this in a procurement, if I were going to go down the sort of hypothetical route that Mr. Coppell went down, I'd have to think, well, how would I do that in a procurement? I'd have to work out what I was asking for, and I'd have to think, how am I going to make that comparison? The whole point is, you don't have to do that.
I see all of that from Regulation 26. And I understand the point that the call for competition and all that flows from that, which is a lot, is then all put to one side. It's slightly odd, though, isn't it, that in Regulation 32, and we're in 32.2c, where it is extreme urgency, it talks about time limits. Sorry, are you coming to that?
That's fine. That's what I'm coming. I'm coming to it just a moment. But you're absolutely right.
I'm glad I've shown I'm on the ball. Anyway.
The The provision says, and it does require, it's not as always that clearly worded, insofar as strictly necessary, where, for reasons of extreme urgency, etc., the time limits cannot be complied.
So that relates to the reasons.
It relates to the reasons.
It doesn't relate to what you're being released from.
Exactly.
Sorry.
Well, if you're way ahead of me, that is exactly my point.
Yeah.
When properly read, it's the judge, or it's the authority deciding it's Friday the 28th of February, I need this now, I haven't got 10 days, there's a reason, I haven't got 10 days to wait to sort this out, I need to do it now. As far as I'm aware, the only appellate decision in the United Kingdom on this provision, or rather on its ancestor, is the Salt case, which you have in the authorities bundle at page 432. Sorry, Ed.
You got the tab.
I think it's tab 16. Sorry.
Yes, it is.
It's the inner house. And it's a case all about whether or not the ancestor provision, which was Regulation 14, would be invoked for the supply of salt or salting roads in Scotland in the winter of 2009. And it's an interest. It tests the contrast because the case arises in both winter 1 and winter 2. So the court has a real set of counterfactuals to look at. The point to draw from it is that the Court of Session makes the point in paragraph 46. I won't read it all out, but they essentially are saying it's not just the 10 days, because you have to allow for a bit more than that. I don't think this point really matters in this case, because it really goes to how long is it 10 days or 12 days or 3 weeks. But it's the last 10 lines or so of paragraph 46. And the court where it says these periods are only one element in a highly regulated tender exercise. Time requires to be taken in relation to, amongst other things, and so on and so forth.
Yeah.
And so it's essentially saying when you're sitting there on the 28th of February, you don't just assume that you have a ready-made procurement to go now and you can do it in 10 days. You have to think about, well, no, I'm going to have to go away and draft some tender documents and set up a process and so on and so forth. While you have that page open, can I make it's a point that is slightly out of order, but it's convenient because it's on the same page. Paragraph 45, it's one of my general observations. My learned friend Mr. Coppell makes much of the burden of proof, narrow construction, and I'll come back to this point, but it is, in my submission, right, the Court of Session is right when it says, in paragraph 45, line 3, no doubt the onus was on the defenders to prove the existence of these circumstances, but once evidence has been heard, questions of onus seldom arise. The court must examine the evidence and so on and so forth. With submission, with respect, well, I would adopt, but then take that further and say the question of the burden relates only to the existence of the circumstances. Yes, the burden is on us to show that there was a pandemic and it was a serious pandemic, and so on and so forth. And the judge has been satisfied that we've met our burden on that. But once we've got over that threshold, there is no further sort of super special burden on us on every stage of what we do thereafter. That is simply thereafter, did we or did we not do what was required by the regulations? And so when a lot of the constant iteration of narrow construction, strict interpretation, and so on and so forth, is simply drawing language from the Court of Justice of the EU in cases such as this, where there have often been some surprising attempts by some contracting authorities to use this provision to circumvent the rules. And it's really just a flag saying, don't use Regulation 32.2c or your national equivalent to circumvent the rules. There's nothing more to it than that.
Whilst you pause, may I go back to something you said about Regulation 18?
Yes.
You said the argument advanced by Mr Coppell under Regulation 18 is not available here. In one sense, obviously, that's right, because there can't be a claim for a direct breach. But in the context of Sir James's ground 3 on bias, i.e. the tension with Regulation 32, surely Mr Coppell can point to Regulation 18 as being out with the scope, still up and running, even if you're able to engage the emergency clause. Is that fair?
I think that must be fair.
Thank you.
He can say the regulation exists.
Yeah, I understand. Good. I just wanted to be clear
Yes.
that's fairly conceded. Thank you.
It is also relevant to note what is not required by Regulation 32. Not only, of course, and we've been through there's no requirement for all of the panoply of courts of competition and thereafter. There's no rule or principle for determining which entity will be awarded this uncompleted contract. There's no actually any rule about deciding how. There's no rule for how to make that determination, other than the general reference to Regulation 18 and whatever other legal general parameters there were. There is no provision regarding performance of the relevant contract, no provision regarding its term. The terms are settled, and the only ongoing basis for a challenge to an ongoing contract would be under Regulation 72 if it were modified. And there's nothing in the regulations that addresses the nature of the. This is answering my Lord's question about the nature of the evidence, but in a slightly different way. There's nothing in the regulations that tells you when chronologically the evidence needs to be prepared. There is a provision in Regulation 84 that says you must have a report available. At some point or other, you must draw up a report which records what you did and why you did it in the future. But there's nothing which says the evidence that you rely upon for Regulation 32 must be written down immediately within 24 hours or anything like that. You invoke, you make your justification, obviously on the basis of what was in your mind at the time you did it, but there's nothing, at the time you took the decision, but there's nothing about the nature of the evidence that you have to rely upon. So, turning to the specific points, and they are suppliers, duration, and scope. Those are the specific heads of challenge under Regulation 32.2c, and I use those shorthands. They are the, and then friend says, because there were other suppliers available, because the duration was too long and the scope was changed. He says those are the three features he relies on, suggesting that Regulation 32.2c was not complied with. As I say, let us unpack what that means. What he is saying is, even if Regulation 32.2c applies, it didn't permit you to enter into this contract. I think that's what he must be saying. So dealing first with suppliers, there is the simple point here is there is no part of Regulation 32.2c which says that strictly necessary means one only. If you if you need more than one supplier, you're allowed to use more than one supplier. It's entirely a matter of factual assessment as to whether or not your selection as to who and how many you went to falls within strict necessity. There might be many instances of an emergency in which it was self-evident that one would not confine oneself to one supplier. You might need diversity of supply for very good reasons in an emergency, for example. You might want to spread the risk of non-performance in an emergency. And of course, in this case, as the judge says in a number of different places, there was evidence that Mr Cummings and Mr Akins were well aware that they wanted these services to come from more than one provider, because they wanted, the word that Mr Cummings uses, to triangulate. Others might just say compare. It just, in the circumstances, it makes sense to have more than one view being passed through. And that's in the judgment at paragraph 110 and 97. There are a number of references to Mr Cummings and Mr Akins' evidence on this, but I think they're all in our skeleton. In the case against us as to which other supplier we are to compare, we were to refer this allegation to, has been a little bit mysterious, but it seems to have evolved in the course of oral submission as boiling down to Jigsaw.
You're getting a look of astonishment from Mr. Coulson, which is apparent to me even with his mask on, so I shouldn't assume that that is how the case has been put.
If it were Jigsaw,
Yes.
or if it were Britain Thinks, whichever it is, there is a real danger, as my lady has observed, that the ultimate logical end point of my own friend's argument is that you are confined in an emergency to the person you happen to be contracting with. Assuming, of course, that that person is providing you with the service that you actually want. And that can't, with respect, make any sense at all. It can't be right that Regulation 32 creates some sort of incumbent advantage, particularly if, as a matter of strict necessity, you have decided you actually need services from somewhere else, or from someone else, or you might need slightly different services. In short, the decision to go for more than, well, this wasn't just a decision to choose public first, it was a decision to source services from more than one supplier, and public first was one of those that was identified as being particularly competent. And it was not a casual or frivolous decision, it was taken on the merits as set out in detail in the evidence. It was a deliberate merits-based decision. And there was plenty of evidence and concern at the time that others, and so Catherine Hunt goes through each of them in her statement and explains why they're a bit different. They weren't doing this, they weren't expected to do this.
Did the judge engage with that?
Sorry?
Did the judge engage anywhere apart from, we've been taken to a few paragraphs, but did she ever refer to that sort of identity by identity response from Miss Hunt saying no, 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 and no?
No, I don't believe she did. I don't think she went through the list. She had that list in front of her, but I don't think there's anywhere in the judgment where she goes through it.
So we get Jigsaw dealt with at paragraph. I don't know the whole thing's up. That's fine. We know where it is.
Yeah.
Para 163, and that's it.
And 111.
111. Thank you.
And she refers to Britain Thinks. I don't think she deals directly with YouGov
No.
163.
163.
Yeah, YouGov's there. So it's
YouGov is
162, 111, 16.
She doesn't, for example, deal with BIT or
Is there somebody called
Cantor.
Cantor. Okay.
Sorry.
All right, doesn't matter. That's fine.
In paragraph, my little friend sort of wraps up his argument here in paragraph 69.
Of what?
Oh, sorry, of his skeleton.
Right.
Sorry,
That's all right.
apologies. I knew what I was talking about. Paragraph 319 of the core bundle.
Yes.
And with respect, he misstates the judge's argument. The judge does not say that something is strictly necessary whenever there is extreme urgency, which is, in my submission, what he's trying to sort of pigeonhole her in. But if more than one supplier is appropriate in the circumstances of an emergency, you would contract with more than one. And in so doing, it is quite possible for going to more than one to be strictly necessary as a means of dealing with the emergency in front of you. And indeed, I would submit that a responsible authority facing an emergency would regard it as strictly necessary to take what would be regarded as reasonable precautions, and that might be to go to more than one source for a number of different reasons. Have a little bit of extra for whatever reason that might be, as a diversity of risk, a little bit of extra time provision, or whatever it is. It cannot be right that strict necessity imposes on the authority an unduly risky approach, confining itself to a limited number of providers. So that, in my submission, is the case on suppliers. It does not go anywhere. The next point is duration. What was the contract duration? Yes, it was 6 months. But, and we can no doubt have a semantic debate about what precisely the nature of this 6-month contract was. It was pay as you go. It did not involve a requirement to accept services over the full 6 months. It was a contract which enabled government to call off the services it needed within that 6-month period, and that is what it did. And as you know, you have in the judgment at paragraph 61 a helpful narrative of what it's done by reference to payments, but you can deduce from paragraph 61 what was done at roughly at what time. And that's derived from a witness statement of Nicola Westerner, which you have in the bundle. There's actually a confidential annex as well in the confidential bundle, but I don't think I need to go into that.
But as you're on this point, tab 10 of the core bundle, starting at page 186, we have the contract, which is a relatively exiguous document, but it has a lot of things attached to it. It incorporates all sorts of things from other contracts, and I have assumed, but tell me if this assumption is right, that everything that's in the bundle behind it is relevant for those purposes. And if you go to page 217, the customer, it says, may terminate the contract giving at least 14 days notice. In other words, I mean, if that term was incorporated, and I'd be grateful for confirmation, the minister could have terminated this at any time, and so it's not right to describe it as a fixed 6-month contract.
I'd have to take instructions.
There are nods from behind you.
I'm being told, yes, it was incorporated, and therefore that must follow from what you say.
Yes.
Sorry, Is my lord referring to 23.6? Is that the provision you're...
I was looking at 23.6.
So if those conditions are met, so if the DPS agreement is terminated, if the parties fail to agree variation or...
Yeah, oh, I see. So are there no straightforward terminate on notice?
No.
Okay, well, I haven't read every part of this. Anyway, all right.
We have not. I mean, it hasn't been part of our case that it was ever terminated.
No. I'm just wondering whether it could be.
We can no doubt check. But, it's not. Our point was simply that, as I think was, I can't remember who made the point earlier, but it fell dormant effectively at the end of July.
Okay, all right.
Before 6 months had expired. It is relevant to note, and you get this from the evidence, that firstly the 6 month period was debated, there's been a lot of reference already to that debate about how long it should be. The 6 month period was actually settled upon on the 7th of April, and you get that from Miss Stratton's evidence, tab 10, page 187, of the supplemental bundles, paras 47 and 48. And the 7th of April, to give that context, hard to remember now, that's the day before the highest death rate in the UK that year, the highest pandemic death rate. So it was, on the 7th of April, the idea that we were through it was obviously a long way, far from anyone's mind. Yes, it took weeks thereafter to then encapsulate all this in a written contract. So what this contract actually did was to provide exactly the flexibility that the defendant needed to meet what was strictly necessary in the circumstances. The reliance by a learned friend on commission guidance involves in our submission a number of errors. It elevates the guidance to the status of law, which it doesn't have. And the guidance interpolates these words in paragraph 2.3.4 of the guidance, and it's page 618 of the authorities manual. And it's that little passage at the back which the friend relies upon. And
sorry, give me the page again.
618.
Thank you.
And he hangs his case here really on the words at the end of the first line. Sorry, I should go back because it makes sense of it. Negotiate procedures, etc., may cover the possibility to meet immediate needs. They, that must be the procedures, cover the gap until more stable solutions can be found. And he infers from that the gap is only to meet your immediate needs. Yes, the gap may be purely temporal, but the gap is not. It is a gap of requirement. You have a service. The gap you have is I need something and I need it now. It isn't a purely temporal requirement, specifically limited to the time limit as specified in Regulation 32(2)C. This gap here is not the same 10-day time limit in the regulation. It is simply saying that there are circumstances in which there is a service gap, as it were, a service provision gap, and you need to fill it until a more stable solution is available. So in our case here, to put it very simply, in March there was a service gap. We needed more. The government needed more input on these behavioural matters. There was an expectation that a stable solution could be put in place by August or so. And looking at that sensibly in terms of time limits, that's not surprising. When one goes back to the time limits that were being talked about for procurement, and you'll recall there was a debate about whether it would take 2 weeks. Different individuals in government were coming up with different periods, whether it was 2 weeks, 6 weeks, 8 weeks. On any view, a sensible person looking to procure afresh in March, April would have thought to themselves, on the basis of the evidence, I probably ought to leave 2 or 3 months to run the procurement and get a contract. I mean, that's what flows from the evidence that was before the judge. Well, you're in March, you have a three-month period that you have to allow for to be safe. You don't want to be left with another gap. So the 6-month period in our submission is a very sensible period of coverage to allow for that period and to make certain that you don't have yet another gap. You don't want to suddenly find yourself without the provision that you wanted. So the strictness necessity is driven by the circumstances, not the timetable of the procurement as such. I don't think I need to say very much more on duration. I'll just quickly deal with scope and then I will sit down. So we've just made on scope, I think our point is very simple, and I've really canvassed it already. The judge accepted that the scope as originally established was an appropriate scope in the emergency. What happened is there was an extension to cover other services. Whether that was legitimate or not might be judged by reference to Regulation 72, but that's not this challenge. And as she said, there was no basis for challenging the performance of the contract, and there was no challenge to that modification or extension of the contract beforehand. And there's no reason why whatever happened in July for that 80 or 90,000 pounds worth of work to be done on what I will call for shorthand the union work, but it's more than that, the non-COVID work. None of that affects the legitimacy or otherwise of the decision that was taken in March. Ms. Lady, I've counted over various things, but I hope that if there's anything else I can assist with.
I think I've read further into the clause, and I think there's a unilateral 3 months notice of termination. But the point you've made about the contract not being entered, it's a 6-month contract, entered rather later than its beginning, and so it seems to have been rendered OTOs. Anyway, I hope I've got that right now. Yes, Sir James.
I'll have a couple of brief points in reply, if I may. You know our case, and I won't go back over it, that there was, in effect, no springboard from which the judge could jump to the requirements that you then sought to impose, in effect. And there was nothing to support the imposition of the requirements, not directly, but through the common law of apparent bias. I don't repeat the submissions as to why there is no springboard. In particular, it is, however, to be noted that it appears that the individuals concerned were friends, in effect, as a concomitant of the work relationship from the past. You see that in particular from Mr. Cummings' statement of paragraph 7, describing his friendship and describing the fact that he hadn't seen, for example, James Frayne since whenever it was when he was working with him at the DFE. And so you're dealing with the mere fact or existence of friendship as a concomitant of a work relationship, no more. It's also to be borne in mind when considering the springboard issue that the informed observer will also appreciate that Alex Aiken was in place and approved the arrangements and the making of the contract as the responsible civil servant. So whilst Mr. Cummings may no doubt have been the driving part of the decision making in terms of public first, the civil service were in place and did perform their function of approving. And that's something which the informed observer could be taken to know. So far as the evidence is concerned, I do respectfully submit that there is a need for some considerable care in approaching how the judge approached the evidence. Care about the ex post facto part of that judgment. And I say care because it very much depends what you mean by that. There isn't, and wasn't, any, as we know, any contemporaneous record of the kind that one would normally have in for example, the context of a ministerial decision, where you'd have a ministerial submission setting out the factors for and against and the reasons for a particular decision. It is, I respectfully submit, questionable whether the ex post facto doctrine that we all know about from public law, how that could truly have any real purchase if ex post facto is intended to mean or convey more than simply there wasn't a contemporaneous record. Hard to see how that could truly have any purchase in the hypothetical exercise of seeing what the informed observer might know or might conclude, appreciating all the facts. This context and that issue is, I respectfully submit, fundamentally different from the situation in which the court has expressed concern about ex post facto reasoning, because what tends to happen in that situation is that you have, for example, a ministerial submission that says reasons A, B, C and D for the decision, and then after the event additional reasons are added to that. Now, it may not be
it arises, Sir James, or I'm trying to think of any cases where this context isn't the context, in public law challenges focusing on the absence or inadequacy of reasons.
Yes.
And then they come along later.
Exactly.
So the public law failing identified
is
a failing to give reasons.
Or an inadequacy of them.
Or inadequacy, and then along come reasons. And there's no rule of law that you can't take notice of them, at least as I understand it. I'll be corrected if I have misunderstood it. But a whole series of cases have expressed caution about the extent to which they should be accepted, and especially in the circumstances you've identified, where there might be some contemporary material, and then along comes other things.
Yes. And the only thing perhaps to add to that, and it just simply provides another context which isn't ours, but as you're very well aware, in some contexts you have a debate about margin in the context of proportionality.
Yes.
And it is said against the government, well, you don't get such a big margin because all this stuff that you're now advancing by way of justification is made up after the event and wasn't in your mind at the time. So we're not giving you any leeway for that. So sometimes, but neither of those two are our context. Our context is fundamentally different. Involves the court doing what is almost in nature an ex post facto exercise itself, of imposing a hypothetical informed observer and then asking what they would make of the facts as found and known. So we respectfully submit that's one reason to be careful in principle about that idea, and we certainly don't accept the way Madame Lefrem was presenting that part of the case. There's also a real need for caution, we respectfully submit, on any fair reading of the evidence. And I know the subject has been explored in the debate today, but we are here dealing with, as is quite clear from the evidence, experienced people who knew the market, who knew the players, who did not, it is true, make contemporaneous records of all their reasoning at the time, but who are setting out in their statements what the thinking was at the time. They're doing so certainly after the event, but they're doing so to explain why they did what they did. That's the short and simple point. And one sees that very clearly from the passages that my lady drew attention to in Cummings, paragraph 8, and then the sentence in paragraph 18, which refers back to paragraph 8, tab 8 in the supplemental bundle, page 132. One also sees it pretty clearly coming out from two passages, which I don't invite you to turn up now. One in Hunt 1, paragraph 36, tab 9, page 147, and the other in Aiken, para 23, tab 7 of that supplemental bundle, page 108. And both of those passages were dealing with the narrative contract, which preceded our one. But both of them indicate that it's entirely clear that the civil service were discussing various different agencies at the time, making judgments between them, knowing what they were both doing and who was involved with them and all of that. So the idea that one comes at these statements, as it were, in a vacuum, we respectfully submit is not a fair or the correct way of approaching the issue.
So how do we approach the findings, the passages upon which Mr Coppell relies at 158 and onwards in the judgment?
Well, my lady, I think the answer to that is that the judge does not explain what she means in 158 by ex post facto.
So her comment that it wasn't part of the decision-making process at the time. I'm actually just referring to the 5 findings. So Mr Coppell would say the finding that nobody considered the possibility of using an alternative agency. Do you accept we're bound by those, or how do we build in your submission just now about contextualising the evidence and reading it fairly overall when we are where we are, so to speak?
Well, my lady, I made my submissions about those particular paragraphs when I was opening the appeal. I'm not going to go back over those.
Mr Coppell says you're essentially challenging the findings of fact, which is not open to you to do.
Well, I don't need to go as far as to challenge them overtly. I can perfectly contentedly ask you, in the context of the challenge of principle that we make, to put those findings in the context of the evidence. There's nothing to prevent an appellate court from doing that. And as I say, there's no dispute about the fact that there weren't contemporaneous records of the reasons at the time. But I do respectfully submit that it is clear that what people were doing was trying to explain why they did what they did at the time. And you are entitled to take that into account, I submit. But on the specifics of those paragraphs, as I say, I've drawn your attention to the paragraphs that bear on them. I have no more to say about that in reply. Rule 32, if I may, and again, given the nature of the exercise that the court is involved in, of seeking through the common law to get into the mind of the informed observer, one doesn't perhaps want to get overly technical about all of this. And so the first point to make about Rule 32, perhaps, is that it sits in a much broader context when you superimpose the informed observer, of understanding that these were decisions that were made in a super emergency with a very serious crisis unfolding in real time and in circumstances in which there was the most considerable uncertainty as to how future events might unravel. So Rule 32 sits as part of a more general understanding that the informed observer can have imputed to him or her about the nature of the urgency of the decision-making that was being undertaken at the time. The observer would also understand, I submit, that the scheme does allow for the ordinary time limits and processes associated with competitive tendering and then deciding about who the contractor should be, not to be followed. No doubt there may, as a matter of technical construction of the regulations, there may be some residual requirements even in the context of Regulation 32, but there has been no case there's a breach of those advanced. It is hard to see in any event how any such breach could, as it were, sound as a matter of common law, but perhaps most importantly, whatever residual requirements there might be, there has been no attempt to suggest that they were anything like the set of requirements imposed by the back door by the judge. And it is at least worth bearing in mind, going through the paragraphs that my lady drew attention to, what those requirements actually were, at least in her mind. A, design objective criteria. B, assess if Public First was, quote, the most appropriate agency. C, use the RMDPS system or something like it to ascertain who they might be, filtering down the 300 that she thought might pop up out of that system. D, contact them or some of them, unspecified number, to see and to probe if they had Roman 1 experience and Roman 2 capacity. And then presumably E, design a system on an objective basis to select between them. That, I respectfully submit, is not any part of the residual requirements there might be if 32 is in play, and they are, as it turns out, not even procurement very light. It's also finally to be borne in mind in relation to this point that the informed observer, says the judge, presumably, would conclude that the friendship of Mr Cummings from the work relationships that he refers to at paragraph 7 were in effect the key to the award, and that should be the conclusion imputed to the informed observer unless that detailed process is followed through, even though there is nothing like that inherent in 32.2. That's the point. That's problematic in its own right. It's doubly so given the 7th point I made in submissions in opening, because we respectfully submit that even were you to conclude that there had been a breach of some form of residual requirement, even if 32.2c is in play, non sequitur, that you would then infer, or that the reasonable observer would then infer, bias by Mr Cummings, still less by Mr Cummings plus Mr Aiken. The 4th and final point I wanted to make by way of reply deals very, very briefly with Boardman. And the short point in relation to Boardman is that Boardman is after the event. The government is entitled to review and re-review its systems in any number of areas. It is entitled to change, to solidify, to add detail to policies and processes. It does it all the time. And that fact, as I think has been frequently pointed out, not least I think by Lord Sumption in the Cat case, does not lead to a conclusion or an inference of prior unlawfulness. If it did, there would be a thoroughgoing and thoroughly ill-advised disincentive on government to improve. So we respectfully submit that that is the short and complete answer to Boardman. It might be jolly forensically attractive to go down the list and say, well, this is all the things that could and should have been done, and look at what the government has done. That tells you it's not impossible. But our case has never been built on impossibility in that sense, or in that form, or unreasonableness in that sense, or in that form. So we respectfully submit that that is the short and complete answer to Boardman. And you will no doubt have noted as you went through Boardman that there is no suggestion in it that any of the recommendations or any of the conclusions that Boardman reaches were driven by any prior conclusion that there was a problem with bias, or in this particular case, or more generally, still less that there had been any form of unlawfulness. So those are the points in reply.
Thank you very much, Sir James. Mr Coppell.
Thank you, my Lord. Replying to Mr Balsher. Mr Balsher made some submissions of principle on Regulation 32, and his position, as you heard, was that once urgency applies, there are no further requirements to be drawn from Regulation 32 or Regulation 18. And I have a few points to make about that in reply. First of all, he has no authority to say that contrary to the scheme of the regulations, that Regulation 18 shouldn't apply. And of course, we accept that it's all context specific, and how much you have to do will depend on whether you're dealing with a nuclear bomb or something less urgent. But the rules are there, and they do apply in the Reg 32 context, and there's no authority has ever been cited to the contrary. Mr. Boucher,
just before you go on, I mean, his ancillary submission was that your clients tried to raise this issue below expressly. You refused
yes,
permission to do so.
yes,
So you can't do so here.
yes, and the point is the one that my lady put to Mr. Boucher, which is that application to amend was put as a different legal way.
It was a breach allegation. It was, as it were, a liability amendment,
Yes,
which was disallowed.
yes, a different legal way of relying on facts and arguments which we had already relied on for other purposes. One of the purposes that we relied on, the absence of consideration of any other bidder or any other agency, was in the context of apparent bias from the start. And just because we couldn't run a different head of breach doesn't mean that we can't make the point at all. And I make it in response to the points which are made against me. Mr. Boucher said, well, we can't. It can't be right that there are any further obligations once urgency applies because there's no rule book. He said, well, how can we be expected to establish a new comparative process without any rules? Well, the answer to that is, firstly, there are rules, and one of the additional provisions of the regulations which I started to read from earlier on, Regulation 67 on contract award criteria, and that is another provision which is not disapplied by Regulation 32. Of course, if you've only got one bidder who can possibly do the job, then there's no question of comparisons. But where you are dealing with more than one potential bidder, or could be dealing with more than one potential bidder, Regulation 67 tells you what the nature of the criteria should be that you should apply. I mean, it's broadly framed, but there are objective rules as to how you should decide between the different people who are under consideration, and again, not disapplied by Regulation 32. And the second point to make as to, well, what are we to do, is to look at what Mr. Boardman said at 275 of the supplementary bundle.
And just before we go there, I know we were given Regulation 67 as an additional.
Yes. Yes.
It's assuming there's been a, or is it? That's the question. Assuming there's been a tender.
Well, yes, it's assuming you have, yes, a tender, an offer from a supplier to do the contract. That may come after an advertisement, or it may not. So, just take a simple example from elsewhere in Regulation 32. One of the bases for having this negotiated procedure without an advertisement is where you're buying something which is traded on a commodity market. Of a different example, there'll be many people who can make offers to you to sell cobalt or nickel or something from a commodities market. You choose between those offers using the guidance in Regulation 67.
Yes, so maybe we don't need to go into this, but Regulation 67 is based upon a hypothesis that there's quite an elaborate process supporting the whole thing. You need award criteria. They have to cover a whole range of circumstances. And I mean, the reason I just asked the question is it seems to be the antithesis of dealing with something super urgently. You know, there's a fire that needs putting out, and these people are nearby. I'm just going to contract them to do it.
Yes. So, my lord, it is long, and it is copied out from the directive in the usual way, but it's not complex. The essential rule is in 67.2 that the criteria must be, see the last line, linked to the subject matter of the public contract in question. So we need to ask Public First and Jigsaw and anybody else, how good are you at doing this kind of work, not what kind of car do you drive, or how large is your office. I mean, there's a little bit more to it than that, but it's basically you need to be looking at price, and you need to be looking at some sort of quality criterion related to subject matter. It's not complicated. That's my submission. Now,
I'm sorry to press on this, because I'm just wondering about context, because I'm grateful that we haven't been given the whole of the regulations, but nonetheless we're island hopping between regulations. We see in towards the end of Regulation 67, we have eight sub-regulations. Then we get to weighting, and the assumption is that there will be weighting as specified in the procurement documents. But is it part of your submission that in an urgent situation, as contemplated by Section 32, that there needs to be procurement documents? Presumably you are.
Well, specify some weighting. Yeah. But my lord, all of course will depend on the context. But a procurement document may be simply the authority setting out, we need X number of focus groups to ask people about COVID, and we need to be told about them on the evening that they take place. Tell us how you would do this and what you would charge, and we'll say 10 marks available for how you do it and 10 marks available for what you would charge. Can be done very simply indeed.
Yes. So you couldn't, for example, you ships sinking in the channel, and you suddenly need to contract a vessel to go and help it. You can't just pick up the phone and say, "Go and help it. Send me the bill afterwards."
Well, my lord, everything will depend on the context. I accepted in relation to the example of the nuclear bomb that of course it's what may or may not be possible in the circumstances, or reasonable to expect in the circumstances.
So distilling it, is your submission that the requirements of Regulation 67 must be complied with to the extent that that is possible, given the context of the emergency that's being dealt with?
Yes. Yes. That forms where it is reasonable to expect more than one bidder to be considered, which may not be the case for a sinking boat. Then they should be considered on an objective basis. As simple as that.
Again, finally from me, and I'm sorry because it is. What is? I'm just looking out the remedies, which start a little bit later on. What are the remedies provided for in the regulations for those who can take advantage directly of those remedies for a failure to comply with 67? Are they the ordinary remedies?
Well,
Can't remember which part it comes in, that's all, and I appreciate that different parts generate different remedies, don't they?
Well, this is part of the main run of the regulations, the remedies provisions for an economic operator.
Yeah.
Declaration, quashing order if you get in before the side order, if you get in before the contract is signed.
Yes, I understand that. So a failure to comply with 67 would generate the possibility of all of those remedies.
Possibility.
Yeah,
yes.
that's all.
You've got to show that it's likely to have caused you loss or damage.
Yes.
But yes.
Oh yes.
Subject to that. Well, I was conscious that you have been asked to island hop, and you may want to see the regulations as a whole to see how
I think to the extent we need them, we'll manage that. They're readily available electronically. I don't wish to encourage anyone to start photocopying furiously.
So, rule book. You've got some provisions of the regulations which still apply, albeit attenuated in the circumstances. You also then have Mr. Boardman at 275 of the supplementary bundle, and this is just by way of expansion on one of the recommendations. Paragraph 23 on 275. Commercial advice should be sought on undertaking due diligence of the supplier market in situations of extreme urgency, including wherever possible and where there is time, by inviting proposals, presentations from a few suppliers to establish which suppliers are best placed to provide the services and verify that any suggested supplier is appropriate for the requirement. This is particularly important if a suggestion has been made to use a particular supplier. This need not be a long or complex process and can be undertaken quickly in situations of extreme urgency. Now, he's not purporting to say what the law is, but no doubt he'll have...
well, even if he were, it would be of no value to us.
No, but we say that what he found, applying his expertise and his brief of seeking to protect against conflicts of interest in the future, what he found is a practical and indeed lawful explanation of what the regulations would require.
And a member of the commercial team, who was there, and what would the equivalent have been in
Be
March
Mr. Sutil
2020?
of the CCS.
Right.
I mean, there may be somebody internal to the defendant, but the point is, it's not much to ask, not too much to ask, to where there is time to think about more than one supplier.
And your submission is that survives in the regulations, even if Regulation 32 is properly activated.
Yes, save where it's impossible. But the judge found in this case, as a matter of fact, that there was time, there would have been time to look at somebody else. It wasn't that urgent. It wasn't the ship sinking, and that's not necessarily for the first evening when in February, but the subsequent engagement of it first.
Sorry, but Mr. Sutil was approached, wasn't he, for advice?
He was at a later stage.
6th of March 2020.
Yes, after the
Right.
initial engagement decision.
Thank you.
But Mr. Sutil, having read the Boardman report and now knowing what the policy is, in the future, if he was consulted, he would be saying, I think you need to talk to more than one supplier about this. I'm sorry, this is taking much longer than I had anticipated.
I'm sure it's my fault, Mr. Cobble, so don't worry.
And the final point in response to Mr. Bowish's general thoughts on Regulation 32 and the need to keep records. The final provision of the regulations which we supplied separately was Regulation 84, which contains two obligations on a contractor contracting authority in Regulation 32 procurement and other procurements. One is to draw up a report which includes the reasons why a particular bidder was selected and why you've used Regulation 32, that's 84.1. And then there's a documenting obligation in 84.7. Contracting authority shall document the progress of all procurement procedures, and they must ensure they keep sufficient documentation to justify decisions taken in all stages of the procedure. So again, in terms of this is too much to expect, the fair-minded and informed observer wouldn't expect it, which how Mr. Boucher was putting it. It's an obligation under the regulations to document what you are doing while you are taking decisions. So very shortly then, the three grounds for the cross-appeal. Alternative providers, we rely, just to make this absolutely clear, on Britain Thinks and Jigsaw, and also on YouGov, who is dealt with in the judge's judgment. All three of them had existing contracts with the defendant, which could have been used. Mr. Boucher said the defendant cannot be confined.
So you rely on who? Britain Thinks,
Britain
YouGov
Thinks and Jigsaw. Jigsaw and YouGov are addressed in 163. And Britain Thinks. You've got 110 on Britain Thinks and 111 again on Jigsaw. Mr. Boucher says the defendant cannot be confined in an emergency to dealing with the people he has already contracted with. Well, we say that depends on the facts. If what you need, services that you need, are not readily available from the people you have contracts with, well, fine. Then you need to do a procurement, and Regulation 32 may be in play. But that's my point. You start with widgets, which is easy, and then you scale it up, and then you think about more complex services, and it will all depend on the facts as to whether those services are available from the people with whom there are existing contracts. And the judge found in this case that they were available. That Jigsaw could have been briefed. They did in fact do the work a few weeks later. So that's alternative providers. Duration of the contract. Mr. Boucher took you to 2.3.1 of the Commission guidance note, and I'm not sure there's very much at all between us in terms of what that means, and that's the one that you. I'm sorry. 2.3.4 at page 52 of the judgment, covering the gap until more stable solutions can be found. But the judge didn't accept that the duration of the contract should be measured against the time that would be necessary to conduct a competitive procurement. And as I said before, that may be the time that isn't strictly just the time limits and the regulations, but also how long until there is the capacity to do the procurement. But that's simply not what was done in this case. And finally, on the scope of the contract, the scope of the services, Mr. Bowsher seeks to exploit wording in paragraph 60 of the judgment that the services in July 2020, the services provided by Public First under the contract were extended to cover qualitative research into EU exit topics and themes, attitudes to the union and so forth. And he says, well, extended, the judge is talking about a change to the contract, and this is therefore a matter of subsequent performance and not a matter of what was awarded in the first place. And we say that is the wrong reading of extended to cover. As a matter of fact, Public First's work was extended to these different matters. They were asked to do different work, but there was no change to the contract.
And there was evidence on this, was there? There must have been one way or the other.
Well, the evidence was there was no change to the contract. Right. Never suggested that there was, and the reason why there was no change to the contract is that if you look at the way in which the services were described at page 189 of the core bundle, what Public First did in July fell exactly within the broad specification.
That's the point the judge makes at 121. The services were described in very general terms. And then she sets them out. Yeah.
Yes. So there was no change. There was no variation of the contract. What happened was these services were understood from the start to be of a broad nature and not limited to what was urgently required. Those are my submissions. Thank you for the second.
No, thank you very much.
Well, Mr. Coppell, thank you very much indeed. We will take time to consider our decision, and we will let you have a draft judgment or judgments in the usual way in advance of handing down, and invite corrections in the usual way. We're very grateful to all concerned for both the written submissions and also the oral submissions today, and you will appreciate that we can't give you today any indication of when the judgment will be